Well, I'm Mike Bernhard, and what I would like to talk about is how these regulatory systems that we can see don't work for us, how they came to be. It's a history lesson. And I'm just going to read from my script here. Following the Civil War, an explosion of economic activity based on steel, fueled by coal, sourced and traded globally by railroads required huge pools of finance capital. Finance capital favored and intensified the consolidation of industries, which we identify as the rise of the robber barons. This intensified and consolidated industrial system required a bottomless pit of laborers who had no bargaining power. And so we identify this age also as one of immigration, of tenements and sweatshops. Conflicts over wages and conditions led to pitched battles in coal fields, in steel plants, on railways, conflicts that were most often regulated by the U.S. Army. The intensified and consolidated industrial system also required and created a professional class, engineers and managers and accountants and teachers and lawyers, that was invested in the system through higher levels of incomes and assets, status and market power. This more secure class had consumption-based issues, tainted food, monopoly pricing of goods and services, limited access to new technologies such as telephones, electric power, and cheap transportation. Around the turn of the last century, these two threats to a smooth functioning of the industrial system, one at the point of production, another at the point of consumption, required and created what we are dealing with today, a system that regulates economic activity outside the democratic process, in that it removes economic issues from the will of the majorities, and insulates those industries from certain market consequences. High school versions of history that we were subject to leave us with the impression that the era of the robber barons and labor strife and Upton Sinclair's jungle somehow morphed into a progressive era. By this reading, the excesses of the former period were expunged by the application of Teddy Roosevelt's manly trust-busting and the establishment of a host of independent, politically neutral, professionally staffed agencies that would guarantee that there would be no rat feces in our hamburgers, that medicines would work as they were claimed, and that there would be no insider trading on Wall Street. The first leading example of these regulatory agencies was the Interstate Commerce Commission. Like all the independent regulatory commissions that followed it, independent in that it was a multi-headed, each commissioner having staggered, overlapping terms as distinct from later regulatory agencies that have a single head appointed by the president and residing within an executive branch cabinet office. The Interstate Commerce Commission was established to blunt the conflict that arose in the decades after the Civil War, remember, between the railroads and the farmers that had to ship their stuff to market. Elevator rents, rate discrimination, monopoly pricing, and other causes of deadly agitation on the part of the farmers would be dealt with by what we would call today technocrats on the commission staff, who would be dispassionate, scientific, and politically neutral in setting rates and schedules and other conditions, rationalizing the operation of what were called natural monopolies. It doesn't really make sense to have 5 railroads coming into Afton, after all. The best of both worlds, economic power and advantages offered by monopolies, tempered by expert professionalism. A raft of regulatory commissions followed to deal with the abuses of concentrated capital, is the story. Monopolies. In food processing, pharmaceuticals, mining, securities trading, air transportation, communications, and so forth. Today, we in this movement are aware of the Federal Energy Regulatory Commission, and on the state level, the Bureau of Oil and Gas Regulation, the Public Service Commission, and various agencies that pretend to regulate these industries through permitting processes. 100 years after the first flush of these regulatory agencies, anyone involved with them as activists, defending public airwaves, environmental health, transparent government, community economics, economies, and any other aspect of public life at odds with the preferences of profit-seeking capital can and does assume that the agencies or agencies that regulate that field of activity is captured by the industry it purports to regulate. When did this capture begin? The answer is right from the start. The U.S. Attorney General that was in office not long after the ICC, Interstate Commerce Commission, was established, was asked if he could do something to get rid of the ICC. Quote, "The commission is or can be of great use to the railroads. It satisfies the popular clamor for government supervision of the railroads, at the same time that supervision is almost entirely nominal. Further, the older such a commission gets, the more inclined it will be found to take the business and railroad view of things. The part of wisdom is not to destroy the commission, but to utilize it." For this particular commission, the enabling legislation assured inadequate enforcement powers, left railroad safety issues to this non-regulation of the states, left key issues like short-haul and long-haul fare discrimination to the commission's interpretation rather than it being in the statute, and excluded what it deemed to be non-economic issues of race discrimination in transportation, which of course lasted into my lifetime. The result is that the commission acted on the interests of railroad and trucking companies and set rates at an artificially high price at the same time, which at the same time excluded any competition through restrictive permitting. So the monopolies that nominally regulated by the ICC were actually protected from market forces that might have threatened their capacity to control prices, costs, and production from the boardroom, and protected from the power of communities to legislate control through the ballot box. The Federal Trade Commission, Federal Communication Commission, Security Exchange Commission, Consumer Product Safety Board, the Nuclear Regulatory Commission, the National Labor Relations Board, the FDA, the EPA, the FERC, any contact that any of us have had with this alphabet soup of regulatory agencies and commission has resulted in our learning that they serve the needs of the monopoly capital and serve to deny us meaningful control over our communal and sometimes personal lives. In the struggle in which we're joined, we see quite clearly that the agencies that nominally regulate the industry, which in fact exercises monopoly economic powers to set price and production levels, one, removes the decision-making from communities that host these activities, effectively allowing corporate boardrooms to determine the nature of our communities, and two, insulate those industries from market forces. Thus, the regulatory agencies confer on the corporations compulsory integration in gas drilling and gas storage, eminent domain in siting pipelines and power lines, and stay tuned for the siting of generating facilities. After the Deepwater Horizon, or BP, blowout in the Gulf of Mexico, the Minerals Management Service, which had the regulatory responsibility of offshore oil drilling, declared a moratorium on the issue of new deepwater drilling permits. The Cabinet Department in which the Minerals Management Service was birthed, the Department of the Interior, is headed by Ken Salazar, who as a senator had voted against the amendments to repeal tax breaks from ExxonMobil and other petroleum companies, and who in 2006 voted to end protections that limited offshore drilling on Florida's Gulf Coast. Barely 3 weeks after the disaster, he had issued 5 more permits, and in March 2011, the renamed MMS began to issue more drilling permits in the Gulf of Mexico. We need only to briefly mention recent activities of regulatory agents to remind ourselves of their role in maintaining monopoly powers in the marketplace and depriving us of economic democracy in our communities. We know the role of the FCC in turning the public airwaves over to monopoly broadcasters and quashing community radio. We know the pollution of genetically modified organisms in our environment was enabled by the flying wedge of the FDA, the EPA, and the USDA. We know how the New York Federal Reserve Bank, nominally regulating Wall Street during the recent real estate bubble engineered by banks and hedge funds, in turn engineered the purchase by the Fed of the credit default swaps that AIG had sold to Goldman Sachs, Merrill Lynch, and Deutsche Bank at 100 cents on the dollar. We know that the Nuclear Regulatory Agency, which has never refused a permit application, recently approved a 20-year extension for the Vermont Yankee plant, despite the overwhelming vote of the state legislature to deny the extension because of underfloor pipes known to be leaking radiation. With this knowledge being widely shared in its contours, if not in its particulars, how is it that people who are appalled by the prospect of gas drilling or high-volume hot refracking or waste injection or dilution and dumping, or however they conceive, like the blind men and the elephant, of this corporate profit opportunity, think that any appeal to the regulatory process will save our skins? Thank you.
Ben Price again with the Legal Defense Fund. I'm going to be real brief. I know we're running behind time. Just wanted to say that regulatory structure of law is the consolation prize for the stripping of rights. It creates the illusion that we have a democratic process and that we can get the outcomes we need to protect ourselves and our families and our communities, when in fact it does the opposite. Regulatory law regulates us. It makes our strategy, our thinking, our organizing predictable. Environmental law isn't the only kind of regulatory law. Labor law is regulatory law. National Labor Relations Board is a regulatory agency. Why? Because the rights of workers aren't being recognized. The relationship of workers between the workers themselves and their corporate employers, that's what's being regulated. Their rights are not being recognized. We might say that under the 13th Amendment, they have a right. There was an abolition not only of slavery, but of involuntary servitude. Well, I guess if you're working under conditions you don't agree to, you might describe that as involuntary servitude. But the 13th Amendment is not where the courts or the legislature recognize the rights of workers. They don't recognize them at all. They recognize workers as a component of the economy. And so they're regulated. I'm going to say the most controversial thing I've said so far, and that is that there's never been an environmental movement in the United States. Why do I say that? Because movements advocate for the fundamental recognition of rights in law. That's what the women's movement was about until they settled just for the vote instead of equal rights. And I don't mean they settled. That's what they were cornered into. That's what we got out of the civil rights movement of the 60s. Most of the laws, most of the decisions that were adopted were couched within the Commerce Clause, not within the 14th Amendment's recognition of equal rights or equal protection of the law and due process of the law. The 14th Amendment was very clearly handed to corporations in 1886 in the Santa Clara case, and ever since then in reinforcing decisions. But the rights of people, not so clearly ensconced in the fundamental law of the land. And when I say that there has never been an environmental movement in the United States, it's because we've settled for regulating, mitigating harms, so-called best practices, which I would argue that best practices means banning fracking. That would be a great practice. Except for we're not allowed to actually protect the rights of our communities and of the ecosystem, because they're not recognized to have those rights. And guess what? We haven't fought for them as such. And so shame on us. Imagine if the abolitionists had said, you know, slavery is really horrible. What we need is a slave protection agency. What if that's what they did? Well, that's what we're doing. And we have to come up with a better way of understanding what the problem is. The problem is the fundamental denial of rights. Nature, under U.S. law, is seen to have a legal status only as property. Gee, that's the status slaves had before the 13th Amendment. They couldn't have rights. They had no human and civil rights because they were simple property. But the property rights of the slaveholder, they were ensconced in the Constitution and the Fugitive Slave Clause of the Constitution. Well, we got rid of slavery, but we never got rid of the legal theory that says the right to own property is superior to human and civil rights. We haven't changed that yet. No wonder we get the outcomes we do, and no wonder we're told the best we can do is mitigate, slow down the rate of destruction, regulate, and end of the pipe laws that say if you can afford it, you can take the corporation to court and try and make them pay for the damage they did, but we can't fix the damage. Everybody knows you can't fix an aquifer. I'm going to end, I know we're way behind, but I would just hope that you will consider the possibility that we've been had, and we shouldn't settle for regulating when we should insist on rights.